There he is. You have one of those cameras that moves around, Mr. Reader.
Yes, Your Honor. I apologize for that.
Oh,
It's
no,
when
no,
it
no
when it's
need.
off it
Yeah, it
just
folds back up, right? Okay.
yes. So
All right. Okay, Miss Reed. Oh, I'm sorry. Oh, you're the appellant, aren't you, Miss Reader?
I am.
Yeah, go ahead.
Whenever, thank you, Your Honor. Good morning. May it please the court. Jack Ryder on behalf of the Community Redevelopment Agency of the City of Clearwater. Your Honors, we're asking, and I'll reserve 5 minutes for rebuttal. Uh, Your Honors, we're asking that this court reverse and remand with directions to enter summary judgment on the tort claims at issue in this case. And it is undisputed here that the plaintiff, Crumb, never sent notice to the Department of Financial Services. Undisputed, number one. And number two, our position, and I believe it's undisputed, well, this is undisputed as well, is that the June 2023 letter upon which plaintiff has relied as suggesting was somehow adequate, which was sent only the Clearwater, and I'll refer to it as the CRA, addressed only contractual claims. It never mentioned, alleged, or demanded compensation for any tort claim or reference to negligent misrepresentation or fraud, nothing. Now, the sovereign immunity, Your Honors, is a matter to be strictly applied, and the exceptions under 768.28 that dictate the requirements for providing notice in order to have an exception to sovereign immunity are to be strictly complied. And it's critical to the sovereign because it's entitled to these protections so that it has a meaningful opportunity by getting this notice to investigate the claims and to determine the validity of them and to examine them, particularly in light of the broad implications that some of the allegations in this case in the tort context have. And we've cited, there's many cases that stand for the proposition, and we've cited, for example, Department of Transportation versus United Capital Funding. This court explained that the sovereign immunity statute, is in derogation of the common law principle of sovereign immunity and must therefore be strictly construed. And in Smart versus Mong, this court again explained that because Section 768.28 is a statutory waiver of sovereign immunity, it must be strictly construed. And unmistakably, Clearwater CRA is a governmental entity. It was created in 1981 by the City of Clearwater Resolution 81-68, created under the Florida Community Redevelopment Act of 1969 with its purpose, and this is in our appendix at 729 through 734, where it was the initiation of this, was to implement community redevelopment activities like reducing blight and improving the tax base. And in Margate Community Redevelopment Agency versus New Urban, the 4th District explained that the Margate Community Redevelopment Agency, which was created under the same act that the one in this case was created, enjoyed sovereign immunity for tort claims. And the bottom line here is that let's start from the fundamental failure that is undisputed here as a matter of law, and that plaintiff Crumb failed to send notice to the DFS, Department of Financial Services. And that's mandatory. It is a mandatory matter unless it is against a municipality, a county, or the Florida Space Authority. And the CRA is certainly none of those. The concept of a municipality, let me start with that, is a legal entity consisting of a population and defined area, City of Tampa versus Easton. And the elements essential to the existence of a municipality are a, quote, community of people and a territory occupied by them. And that was noted in Lederer versus Orlando Utilities Commission. Here, the CRA was not created by the legislature through general law or special law. It was created by the city in 1981 under the authority of the statute that gives the city the right to do it. The CRA is not a community of people with a defined territory, and a municipality doesn't create another municipality. A legislature does. And then the plaintiff argues that CRA and the city are one and the same, and that they have shared members. Again, this is not supported by Florida law. In fact, if we look at the resolution, which is in our appendix at 729, the resolution made clear that, quote, when acting as the Community Redevelopment Agency, the commission is acting as a public body, corporate and politic, separately and distinctly from its actions as a city commission. And the enabling statute, which I already referred to, which is 163.3571B, explains that the members of the governing body constitute the head of a legal entity separate and distinct from the governing body or of the county or municipality. So Florida statute, the manner in which the CRA was created, all recognize that these are independent. So the notion, as plaintiff argued in their brief, the appellee in their brief, the notion that somehow the municipality and the CRA are just one and the same, and therefore notice to the city is tantamount to notice to the CRA is not supported by.
Excuse me, I'm concerned because none of this argument was presented to the trial court.
Well, Your Honor, first of all, I disagree that, well, I agree that that specific position, the way I just presented it, may not have.
Well, it was raised in a motion to dismiss, and I believe in the answer that there wasn't proper notice, but at the hearing, it wasn't discussed at all, except opposing counsel in going through their response to the argument made by CRA, mentioned here are some other things that were raised, but they haven't addressed at the hearing. And you know, there was no argument.
So I'll say two things. One, to be clear, our seventh affirmative defense certainly raised that the tort claims are barred by the statute. Let me start with that. And that's
Right. It was in your motion to dismiss and in your affirmative defenses. I acknowledge that, but the argument was never presented to the trial court.
I'm looking at our motion for summary judgment, and I'm looking specifically at the appendix 353-354. Plaintiff failed to comply with Florida Statute 768.28F. Even if Crumb can avoid the statute of repose, and it goes on, and it says the tort claims fail for lack of proper notice under 768.28. The statute requires that before a tort claim may be filed against a municipal agency, the claimant must give written notice of the claim to both the agency and to the Department of Financial Services within 3 years after the claim accrues. So it was right, in the motion.
That's it.
Well, it actually goes on a little bit more, Your Honor. It does talk.
CRA and the city, they're not one and the same, and why in discussion of the Lederer case or how that would apply. I mean, I understand you don't have to bring every detail up in your written presentation to the court. You have to put the court on notice of the issue, but when you had an opportunity to argue it, you didn't. So why would I, fault the trial court for not accepting this argument that wasn't made?
Well, Your Honor, first of all, the sovereign immunity and the concept of sovereign immunity, there are some courts that have held, including the third district in the recent decision, that it isn't even waivable, that it's an unwaivable defense because it's tantamount to subject matter jurisdiction. And I've got a few citations for that.
I don't think I used the word waive. I think I said, why would I fault the trial court for not accepting an argument that wasn't made?
Your Honor, I'm not here to fault the trial court. This is a de novo standard of review. And so I think the point there is that this court has an independent ability, and I would respectfully submit an independent duty under de novo standard to examine whether or not sovereign immunity applies in this context. And so this isn't, when we come up as the appellant, as Your Honor knows, on a de novo standard, I certainly respect the trial court. I respect the trial court's perspective. But this court stands independently with de novo review and does not have to give any deference. And quite frankly, I believe respectfully in this context, it was raised, and I don't believe every single nuance of every single point within the statute does need to be raised, but I would ask the court, I'm looking again at the appendix 353-354, and I stop reading, but it continues. It cites to Lederer, and it talks about the distinction between a municipality or municipal department. And it talks about there the fact that the court found the Orlando Utilities Commission, while being part of Orlando's government and a part of the city, was a separate entity that had autonomy to operate independently. So I could keep reading to the court, but I would respectfully suggest.
Yeah, I know. I read all of that, but I also read the transcript of the hearing, and it was never touched on at the hearing.
Your Honor, I'm not aware, respectfully, of any requirement that a matter presented in a motion also has to be argued at a hearing. This court addresses matters all the time just on written briefs that we don't talk about during oral argument. And I just think, Your Honor, that this isn't about faulting the judge. It's about asking this court to evaluate this case under its de novo standard in light of the significant principles of sovereign immunity. And regardless of whether the specific words were uttered at the time of the hearing, it was certainly in the motion, and therefore it was I believe, well presented and well preserved. And if we go back, if I may, to continue on the issues here, Your Honor, the letter that was sent, the June 2023 letter, was insufficient as a matter of law. It focused exclusively on contractual obligations under the agreement. And this is all, by the way, Appendix 695 through 700. Demanded compliance with warranties. It demanded indemnification. At no point in that correspondence does it mention, allege, or assert, or reference any tort claims or demand compensation.
So let me ask a couple of questions. Is
Yes,
there
Your
a
Honor.
case that says that every claim that is going to be asserted in the lawsuit has to be separately identified and set out in the notification letter?
So the cases, what they say and what they talk about, they don't go through to that degree, but what they do say is the importance of notice. And the notice has to provide the idea, the notion of the lawsuit. And for example, there are cases where I'll provide a few citations where the court, for example, found that even general principle references to claims that were being made. So for example, in Smart versus Mong, this court explained an attorney sent a letter to the sheriff's legal advisor identifying that there was a death, the date of death, requesting documents, and sort of putting the
But the court,
city on
didn't the court or the case point out that there was no assertion of a specific claim to be made?
that. In that case, that is correct. But
So are you
Here's
asking for
another-
an expansion? Are you asking for an expansion of the existing law? Because the cases that I read do not seem to be as precise as what you are suggesting is required.
well, Your Honor, on this, I respectfully disagree with that point, and here's
So
why.
tell me the case that supports that
Staley
argument.
versus Izatoya. The emails again talked about running a red light, injured the client, sought an incident report, but yes, it did not demand compensation. In Vargas versus Fort Myers, this court explained the sufficiency of the pre-suit notice. It says the purpose of the notice requirement is to provide the state and its agencies sufficient notice of claims filed against them and to investigate and respond to those claims. And here, the notice must be sufficiently direct and specific to reasonably put the department on notice of the existence of the claim and demand. Now, I hear what Your Honor is saying, Your Judge. I understand the point Your Honor is making, that here, this was a letter about breach of contract, but it didn't reference the tort claims. And let me say a few things. Number one, the concept of sovereign immunity is about tort claims. It's not about contract claims. So to suggest that the letter that talks about contract claims, when that is not something that needs to be presented under the statute in order to even have the right to avoid sovereign immunity, could suffice, I respectfully submit, would be in derogation of the statute.
Explain to me how anyone is prejudiced when
Or
as soon as a tort
surprised, or surprised.
Oh,
as soon as a tort
multiple
claim
reasons.
is made,
Sure.
your client can assert sovereign immunity as to the tort claims. In fact, your client can assert sovereign immunity across the board. It might lose on certain aspects of it, but it isn't prejudiced from raising it, correct?
Your Honor, I disagree. I believe it was prejudicial, and I believe, Judge Northcutt, it was extremely surprising. Okay, because if we look at I'll explain why. If we look at the original demand letter that was written it's in our appendix, and again, if you look at the letter, it is a reference to this claim of a contract dispute, a contract claim. Why why is it prejudicial? Well, it's surprising because nowhere on the radar was there any suggestion of a tort claim. And by the way,
But the contract claim and the tort claims were based on the same underlying facts, and so you would have a breach of contract, or a breach of a breach of contractual duty, or a breach of common law duty, but you got a breach of duty alleged. I don't know how the city could be at all surprised that one of the bases for relief pleaded were tort claims.
So first of all, the pleading, if I'll remind the court, didn't come up as a tort context until the amended pleading. So just to be
I
clear,
get that. I get
this
that.
is not right. This is not in the original complaint that was filed. So I believe it was certainly surprising and unexpected. Why is it prejudicial? For many reasons, but I feel obligated to start by going back to the fact that the language of the statute is clear and unassailable. And the statute required the plaintiff to identify the claims for which they sought to evade sovereign immunity. And it goes back to the idea, and that's why I said before, Judge Silberman, that sure, they didn't put anything about the letter that they made a demand because it was a contract case. But then all of a sudden, when they switched gears and all of a sudden they did surprise us. And how is it prejudicial? Because tort claims are fundamentally and inherently distinct from contract claims. Tort claims give rise to the theoretical threat of, that implicates all sorts of potential issues, not only from the monetary standpoint, but also facially, right? These are negligent misrepresentation, fraud claims. Tort claims are distinct. That's why that's why sovereign immunity requires notice, because it's a fundamental distinction. So
Mr. Ryder, give you a heads up, you're at your 5 minutes. So
I understand, Your Honor.
proceed as you wish.
Understood, and I appreciate that. So I certainly want to highlight the fact that this is a matter of law, that it is a question of this court's de novo standard, that the language of the sovereign immunity statute is clear, and the entire premise of being able to circumvent the requirement to provide this notice by sending a letter that says nothing about tort claims and trying to shift gears years later and come in and say, well, now we want to advance tort claims without doing the notice would be fundamentally contrary to the clear and unambiguous language of the statute. And we've cited cases like Smart and Staley, where courts, including the Florida Supreme Court and other courts, have made it clear that it is not up to this court to in any way rewrite, revise, or redact, but to apply it exactly as written. And I would respectfully ask that the court do that in this case, and that the court reverse and remand with directions to enter summary judgment for CRA. And I'll reserve the rest of my time for rebuttal. I know I've used some of it. Thank you.
You have about 3.5 minutes.
Thank you.
Ms. Reed?
May it please the court, Janaea Reed on behalf of the Appellant Crumb Properties 2. Clearwater CRA attempts to disentangle itself from the City of Clearwater, but it can't based on this record. The CRA entered into a commercial transaction with the approval of the city to sell city-owned property to a third party under blatantly false pretenses. The CRA expressly warranted in a development agreement that burials that were on the property as part of a cemetery were no longer there, and that the property was free of human remains. But those representations and warranties were blatantly false. The breaches of the development agreement have already been determined by the trial court and in fact conceded by Clearwater CRA. But with this interlocutory appeal, CRA tries to avoid liability by arguing that Crumb was required to notify the State Department of Financial Services about related tort claims despite a clear statutory exemption for notice of claims against municipalities. CRA asked this court to ignore the record evidence that exposed what is going on here in terms of the Clearwater CRA being a part of the city. Indeed, the city's own organizational chart lists the CRA as part of the city. We pointed out also these facts to the trial court, and the trial court determined that the summary judgment should be denied in all respects. I agree with Your Honor that Clearwater CRA raised none of these issues in the summary judgment hearing, but we certainly did. We pointed out all of the facts showing how Clearwater CRA and the city are entangled. And CRA addressed none of it. When you look even at the documents that are at issue in this case, the development agreement as well as the assignment and assumption of the development agreement, all of it approved by the city. So this notion somehow that the city and the CRA are completely separate entities was completely belied by the record, and I'd like to start there. As part of the record, I already mentioned to you about the fact that the organizational chart of the City of Clearwater lists CRA as a component entity. The CRA has no employees. All of them are city employees, city staff, completely run by city staff. The CRA's current executive director's paycheck comes from the city, and he reports directly to the city manager. So again, I can cite all of the record sites: Supplemental Appendix 433, Supplemental Appendix A64, Supplemental Appendix 317. All of these factual issues were put into the record before the trial court, and the trial court determined that there was enough to go forward. I'd like to also go to the case that Mr. Ryder talked about specifically, and the only case that was really referenced and cited to the trial court, which was the Lederer case. And the Lederer case is what specifically here compels the very result that the trial court reached. Lederer itself talks about the fact that when you're looking at this notice issue as to DFS and whether or not notice is required, you look at the control with respect to the municipality and whether the municipality has control over the entity. It's clear under the statute of the waiver of sovereign immunity that notice to DFS is not required with respect to a municipality. Now, CRA wants to say we're not a municipality, all of that, but again, it comes back to Lederer, which was the case that they relied on and the case that we talked about in front of the judge. And in that case, it specifically talked about the fact that you look at control. We established in this record that the city has nothing but control over the Community Redevelopment Agency. As I mentioned, it's already listed as one of its component parts. And so, again, I won't go into, ad nauseum about all of the evidence that was in the record about the control that the City of Clearwater has over the Community Redevelopment Agency. But to the extent that there's an argument somehow that the trial court made an error, I would respectfully disagree with that assertion. I do want to turn next to the issue of what was raised about the pre-suit notice and whether or not that notice was somehow deficient. Mr. Ryder has made suggestions somehow that there was a letter that we were somehow required to notify them specifically about tort claims, and that's not simply the law. The law specifically provides, in fact, this court's case, Wilson, out of the 2nd District, which is cited in our briefing. Specifically, the court has held that the pre-suit notice only needs to be in writing, and it needs to assert a demand for compensation. Another case that we cited in our briefing rejected the very argument that Mr. Ryder is making here, suggesting somehow that you have to specify the types of claims that you're going to bring in order to give proper notice. That is the Gordon case that we cited in our briefing, specifically rejecting the notion that you have to list claims. It said the requirement of presenting a claim does not mean that the claimant must present its future legal theories. It rejected the very notion that Mr. Ryder is attempting to assert here somehow, that we have to tell you what exact claims. This was a 5-page letter that detailed exactly what was going on here. And for now the CRA to pretend that they did not have notice or that they didn't know what was going on is egregious. I would point the court specifically to the letter. In fact, I want to make sure that I have the record cite the response from the Community Redevelopment Agency to our letter. So this notion somehow that they didn't have notice is, I want to point the court to A701 and 702, because it specifically belies this notion, number one, that they didn't know, and number two, that it wasn't specific or didn't raise the notion that this was a demand. In fact, the Gray Robinson law firm, for which Jack Ryder represents, is part of that law firm. Their response letter to our letter was entitled it a demand letter. They said, this is a demand letter. I have now had the opportunity to review your demand letter and additional background documents. It also suggests that they conducted an investigation, the very investigation that he's suggesting now that they didn't have the ability to be able to do. So to suggest somehow that we had to tell them a specific or mention the word tort is belied by the 2nd DCA case law that we've cited in our brief. I do want to also address a couple of other points that have been raised here. Because this notion that somehow they are not going to be able to assert sovereign immunity, I do want to address that clearly. The order here by the trial court did not address sovereign immunity. It did not suggest that CRA does not have entitlement to sovereign immunity. That's not what it did. What the order said is that they did not establish that they were entitled to the defense of lack of proper notice. So, I want to be clear on that point, because to suggest somehow that they have now been disabused of their ability to have sovereign immunity, that they have somehow are going to be hauled into court to defend claims when they entered into a contractual agreement for which no sovereign immunity applies, I think is improper based on all of the different things that we've just discussed. Additionally, I would also add, we pointed in our briefing that this interlocutory appeal is for all of the reasons that we've even been discussing here. The tort claims are absolutely intertwined with the contractual claims for which there is no immunity. We've specifically asserted the fact that if you don't, to the extent that you decide that this case on the merits, we do believe that you should affirm the trial court's order denying their summary judgment. But even in the alternative, this interlocutory appeal is not appropriate because of the fact that these tort claims are stem from the exact same basis as the contractual claims. And we've cited multiple cases in our briefing talking about the fact that even when 9.130 provides the ability to appeal a certain order, that does not mean that the order should be taken up when it is intertwined with claims that remain pending and that are still pending in the trial court that relate to the same exact nucleus of facts. Mr. Ryder has not suggested whatsoever. He has made points about the fact that tort claims are separate from contract claims, which is true. But the case law with respect to analyzing this interlocutory appeal issue is whether it has the same nucleus of facts. And I don't believe there's any basis in which you'd be able to say that there is not the same nucleus of facts in connection with this particular case. Now, I also want to address briefly the fact that the notice issue with respect to preservation. Again, our argument has been that, yes, they may have raised the issue in their summary judgment briefing, but in their answer to the complaint, they specifically talked about the fact that there was no notice, no mention of DFS whatsoever. And so now to come 2 years into this litigation, and now we're talking about DFS and all of the evidence that I've talked to you about the fact that CRA is part of the city, we feel that this is an order that should be affirmed swiftly. And to the extent that the court has any further questions, I would yield my time and ask that you, affirm the order. And in the alternative, if you do not affirm the order, then dismiss the appeal for the fact that this should wait until the entry of final judgment.
Thank you, Ms. Reed. Mr. Ryder.
Thank you. Let me go back to this issue of prejudice. First of all, the prejudice that we face derives from the fact that we now are not able to investigate and defend tort claims 25 years after they allegedly occurred because of the passage of time, as opposed to contract claims, which can be gleaned from the four corners of the documentation provided. And, Judge Silberman, you asked if we're expanding the case law, but it's the appellee who's trying to expand the statutory word municipality to include a separate entity that the legislature has made clear is not a municipality. So I want to make those points right off the bat.
Well, that's why I brought that issue up. But the Lederer case focuses both in the majority and the dissent on the extent of connection between the city and the organization. And so it seems to me that is a valid issue to be discussing.
And here, Your Honor, there is nothing to suggest as a matter of law that the CRA is so intertwined with the city so that it should be kept treat it as if it was one and the same. I mean, it was created exactly in the, I mean,
Well,
we've.
if that's not clear as a matter of law, then the trial court properly denied summary judgment, because then there's an issue of fact, isn't there?
But number one, that is not, I don't believe that was the reason why the trial court did deny summary judgment. I don't believe I don't recall now if the judge identified that unique issue as the specific basis on which he believed there was an issue of fact. But the question of sufficiency of the notice is a matter of law for this court to evaluate. And I have to highlight, I mean, in Lederer, the court found that there was in fact improper notice given and affirmed the sovereign immunity application. And I do need to note, in the concept of negligent misrepresentation, fraudulent inducement are independent torts that are completely distinct from contract. We've cited multiple cases for the notion that tortious conduct, particularly those torts, predate contract, and the way it has been alleged here, they predate the contract by a significant amount of time, and that goes back to the prejudice, because it makes it impossible to defend. And this idea that the claims are intertwined and therefore this court wouldn't have jurisdiction, the case cited, I just have to highlight this, the case cited for this point in Crumb's brief was the Haynes case, which was decided before the rule came into effect that allowed for immediate review of non-final orders on this issue. And in that case, they found no jurisdiction because there was a pending counterclaim and they sought to appeal it as a final judgment. So I know I'm at the end of my time. I would ask this court to apply strictly the language of the statute, because we have been prejudiced. We were certainly shocked when this happened. And I'd ask this court to reverse and remand with directions to enter judgment as a matter of law. Thank you for your time today.
Okay, thank you both very much. In order to leave our courtroom and go off into the ether, you need to click the leave button in the